Okay, hello everyone. My name is Carly. I'm with the support team here at Corporate. I figured I would quickly introduce myself since you're all probably used to hearing Tori on these webinars, but I will be taking over for her today. So thank you all so much for joining our November California Brokers Business Accelerator on current real estate matters and broker updates. Today is going to be hosted by Ryan Rosas, but also featuring Michelle Beason and Thomas Bullock. I want to quickly remind you of a wonderful product from SharpTC, our in-house transaction coordinators. SharpTC will not only be your transaction coordinator throughout your entire transaction from start to finish, but when your transaction closes, your clients will receive a closing gift box directly from you. But you don't actually have to lift a finger. SharpTC does all the work. Each transaction that's done with SharpTC is only $400, but you can get your first transaction done for $250. Today's webinar is sponsored by our preferred lender, Movement Mortgage. With that being said, let's go ahead and get started with our California Brokers Business Accelerator. Remember, if you have any questions during this presentation, you can type them in the chat box on your Zoom control panel, and we will do a Q&A at the end of this presentation. But I'll now pass it over to our brokers, starting with Ryan. Good morning, Ryan.
Good morning. Thank you, Carly. And happy holidays, everybody. We have Thanksgiving coming up next week. I know that we're all really excited about that. So I hope you guys have some fun plans scheduled for that. Considering the times, we could all use that. Today's Brokers Business Accelerator is around personal property and a real estate transaction. I've actually had a lot of my agents asking for us to do a topic like this for quite some time, and we've actually been wanting to do it, but with COVID, our topics have changed over the last month so that we can keep pace with that. But we wanted to bring it back and touch base on this because we do have a lot of people that are asking us, or asking me at least, about how personal property can be involved in a transaction, what are best practices for that. And so I just wanted to review that with you guys. So really, when it comes down to personal property, the general rule of thumb is really, we shouldn't really be including it in real property transactions in the first place. I mean, that's really the best piece of advice. And part of that is that in California, there are different civil codes, which are our laws. So civil codes, commercial codes, code of civil procedure, and that's what governs the different type of transactions that we see, whether it's collecting sales tax, whether it's a real property transaction. And so once you start commingling personal and real property, you're starting to cross over how those are being engaged with different procedures. And so you just want to make sure that we're not doing something that could be in violation of one of those civil codes. But not just that, we also will have lenders on most of our transactions, and the lenders don't want to see personal property involved in a transaction because do they now have to have an appraiser come and consider that real property in a transaction? So just, for general rule of thumb, it's best to keep those out. But I will drill down into the contract a little bit today and let you guys know what the contract actually says. So in the purchase agreement in section 8 is really where we're going to see the specifics around the personal property that's involved in a transaction. For the most part, if it's attached to the home, it's considered to convey with the property. There are some exemptions to that. As an example, if you're attaching personal property to the home for the sake of earthquake protection. So your TV cabinet is mounted to the wall so that it doesn't fall over in the case of an earthquake. It's the TV cabinet is still considered personal property, even though it's attached to the home. So really what you want to do is know what is considered personal property and what isn't considered personal property. We see a lot of times where an agent will ask me, are the window coverings involved? I know that the bar up top is attached, but the actual curtains are not. How is that interpreted? Or there's a water fountain outside and it's not actually bolted to the ground, but it's part of the property. So again, all of this stuff, for the most part, is going to be identified for you in section 8 of the RPA. One of the things that we want to make sure that you guys are doing is, if for some reason personal property is being included in the sale is to double check with your brokers ahead of time to see exactly how that needs to be done. Again, we advise against it, but there are circumstances in which it could potentially be included. As an example, I oversee the Tahoe Truckee area up here in Northern California, and those are second and third homes, and a lot of those homes are sold with furnishings included. So what I always advise my agents is to have the buyer and seller have a separate written agreement outside of the real property transaction to convey that property. If for some reason the buyer and seller are adamant about having it in the purchase agreement, we need to have something to balance it off. So what we normally recommend is to have a bill of sale, which is CAR form BOS. And what that does is it will identify the particular items that are being included in the sale and what value they have, if any, as a part of the full transaction. A lot of times you will see that agents will want to just write it into the purchase agreement in section 8, the 8B3, they'll say, hey, I want to add in this couch, or I want to add in this TV, and it's at no value and no warranty. Again, that really should be done outside of the transaction, but you'll absolutely want to double check with a lender to see if that's language that they will be okay with. Section 8 does automatically state that anything that the seller is willing to include in the sale of the property does come without warranty, regardless of the value. So it's already built in there that there's no warranty in there provided by the seller. Unless there's, for example, let's say that there's the refrigerator included. The seller isn't providing their own personal warranty, but if the manufacturer has a warranty, you know, we'll want to make sure that that gets transferred over to whoever the new buyer is. So really some of the things that I've seen that are things that stick out are I've had agents write in treadmills. I've had agents write in tractors, trailers, different things like that. Those are really the kind of things that we're going to call out, and we're going to ask you to have an addendum to remove them and do a separate written agreement. The type of personal property that I'm more comfortable having is really going to be stuff that belongs to the house. So is the washer and dryer, is the refrigerator, the microwave, things like that that are actually kind of part of the property, as opposed to something that is specifically really something that they went out and bought at Best Buy and installed separately, or something along those lines. So really the best frame of mind is to always ask ahead of time. But we want to make sure that we're covering the bases for the liability of our agents, so that if something does go awry, our agents aren't having to foot the bill to pay to replace personal property. As an example, and I'll go back again to the Tahoe Truckee area, because again, there's a lot of personal property involved in that area. There was a deal that included personal property, and the deal actually fell through, and it became kind of a tension situation between the buyer and the seller. And the buyer said that they planned on still keeping all the furniture because they didn't make the furniture a condition of the sale of the property. They said, listen, you agreed to give me the furniture. I want the furniture. We didn't say anything about it, you know, being contingent upon the property closing. So again, it can get really complicated and really complex. And in cases like that, it will cost the agent a pretty significant amount of money. So best rule of thumb is just to keep it out. Really though, this panel will probably be better for answering specific questions. So that's kind of my general overview of it. And I'll ask Tom and Michelle if they have anything to add, but I'd really love to just be able to answer questions if you guys have specific questions about personal property in the transaction. So Tom, I'll pass it over to you, see if you have anything you want to add on this one.
Okay, great, Ryan. Thank you. Excellent presentation, by the way. You know, just a general rule of thumb that I like to follow is, if you can pick up an item and carry it out of the house and put it into a moving truck, that's personal property. Anything that would require you to unwire, unscrew the actual structure of the home itself, you need to, that could be considered or construed as being a fixture. So, you know, that's not completely accurate, but it kind of gives you a rule of thumb to go by. When you're going through the home, just, you know, this is just kind of a sidelight to all of this. In the RPA, it states that the refrigerator, cooktop, oven are to be included. Now, if you're going through the home and the refrigerator happens to be a Sub-Zero, or the oven cooktop happens to be a Viking or a Wolf, then you may want to identify that in the RPA where the section about the refrigerator, cooktop, and oven are, because I've had instances where I've seen there's been, actually it was a Sub-Zero refrigerator, and when the buyer got ready to move in after they closed escrow, there was the refrigerator that was in the garage were now in the kitchen, and the Sub-Zero was gone. So you want to make sure you identify brand names if they're being shown at the time your negotiations are going on. You just want to be careful more than anything else. You know, fixtures and personal property, what I'd like to see is, you know, as Ryan was saying, put it on a bill of sale. Now, when the verbiage on that bill of sale should read, just to protect you, the agent, as well as the buyer, that and the seller for that matter, so there's no confusion later should the transaction not close, is to state the following personal items to be included with the successful closing of this escrow by the buyer. That way, if it's not a successful closing, then that bill of sale becomes null and void. So that, you know, just wording is so important in our world today, because we're seeing, all three of us are seeing some crazy stuff come down the pike with people arguing over little stuff. So, you know, just protect yourself, protect your buyer, protect your seller, and you should be good. That's all I have for right now. Michelle?
Yeah, I just want to add, I mean, everyone's done a great job of covering everything as far as, you know, the personal property goes. But I do want to add, it's very important when you're taking listings that you walk the property and you point out what would be considered a fixture and what would be considered personal property. Because it seems to me most of our issues are in the fact that the sellers don't know. They don't know that their TV mounts are supposed to stay unless otherwise stated in the contract. They don't know that their grandma chandelier can't come. And if they don't know, it means that we as agents aren't having the discussion. So we're not doing our jobs and properly educating them on that. So I just want to encourage you all to have that discussion with your sellers at the listing appointment, at the, you know, when you're signing the contracts or when you're doing the walkthrough of the property, and say, you know, hey, this chandelier is beautiful. Are you going to take it or not? And if you're going to take it, why don't we replace it now before we put it back on, you know, put it on the market? Just have those conversations. You know, our jobs as agents are to educate our buyers and sellers. That's why they hire us. And it's the same when you're walking through a property showing, you know, if they say they really like something, check it out. If it's not going to stay, you might want to say this probably isn't going to stay, and then write it into the contract. So that's really about all I have to add in addition.
Thank you. And I actually have two things. Thank you, Michelle. That was great. I have two things that I want to add really quickly. One is I have agents that will come to me and say, hey, Ryan, this particular item was advertised in the MLS, or it was on a flyer. And now the seller is unwilling to leave it. You know, what are our fallbacks? So the answer to that is kind of what Michelle was just saying, and Tom before that. Unless it's specifically noted in the RPA, it's neither included nor excluded. So it doesn't matter if it's being advertised in the MLS. It doesn't matter if it's being advertised on a flyer. If it's not in the purchase contract, 8A of the purchase agreement says that it doesn't matter. So you have to specifically identify it. The other thing that I really wanted to touch base on is solar. So, so we talk about what items are attached to a property. One of the items, or one of the things that I've just recently dealt with in a transaction between a buyer and seller, is leased solar. Leased solar is considered personal property. It's not considered real property, even though the solar panels are attached to the top of the house. If it comes with a lease, the buyer has to be provided with a copy of the lease with the terms, and they have to be, one, willing to take that over, and two, capable of doing it, which usually requires a credit review and approval by the solar company. So it is a contingency in favor of the buyer if there is leased solar panels, because they are considered personal property. So that's those are the extra 2 items that I had. Looks like we have a couple of questions. Is that right, Carly?
Correct. Brett K is asking, is there an official separate document that you recommend for personal property?
Well, we mentioned it a couple of times. The bill of sale is a great resource that we can use for personal property to be transferred. As Tom said, I think it's important for it to be specifically noted that it's upon the completion of the close of escrow. So that way we don't have something sneaking up on us and saying, hey, well, I have a separate bill of sale, but escrow didn't close, and so I still want these items. But really, because there are complex rules that are, in the state of California, and we have overlapping laws, the best thing to do is to have the buyer or seller touch base with, their attorney, and just have them say, hey, this is what we're wanting to do. Is there a different form? Can I use the bill of sale? Anything like that. That's the best advice.
I had an example. This is going back a couple of years ago, but the buyer was doing, we had the seller, the buyer was doing a final walkthrough prior to the close of escrow. And when they went into the garage, the storage cabinets, which were attached to the home, were there. And a conversation took place between the buyer's agent and our agent, and the seller happened to be there. And it was made perfectly clear to the buyer's agent that the cabinets would convey with the closing of the escrow. And so the escrow closes, and lo and behold, the buyer moves in, and as you can guess, those cabinets were gone. The seller had taken them with him. So for us as agents, when there's some confusion about an item being a fixture or not a fixture, and you have that conversation with your client, particularly in the case of a seller, you want to follow that up with an email to your seller stating, per our conversation today, the garage cabinets that are fixed to the wall are to convey with the property at the close of escrow. They will be left behind, and you will not move them with your personal items. It doesn't mean that's not going to happen, but what it does mean is that you as an agent have taken care of your fiduciary responsibility to the seller to alert them that this item is a fixture, not a personal item. And you don't want to be caught either having to go find the seller and bring the cabinets back and pay to have them reinstalled. You want to make sure that all of that falls on the seller, not you. So as agents, again, keep in mind, we need to protect ourselves in today's world.
Yeah, perfectly said, Tom. Thank you.
Okay, great. Well, it doesn't look like we have any further questions. Do you guys have any final comments you want to add?
Nothing on my end.
Yeah, just in wrapping up here, everything we do as agents is all about communication. It's how we communicate with our buyers, with our sellers, and we need to be in constant communication, number one. Number two, we need to document ourselves so that when we do have that communication, it's in writing, so we can fall back on it. Make it a part of your SkySlope file so that down the road, should anything come up on it regarding any type of litigation, whether it's small claims court, whether it's mediation or a full-blown court case, those files and that communication log, both phone logs as well as written logs, emails, text, whatever, are so vitally important in protecting ourselves from litigation and some financial repercussions that could fall our way. Because once anything goes sideways, the first thing everybody does is they point at the real estate agent. So, again, you don't have to be out of bounds with your communication level. Be nice about it. Just say, hey, Mr. Seller, great seeing you today. By the way, I just wanted to emphasize regarding our conversation on the garage cabinets. They are a fixture. The buyer is expecting that to convey with those items to convey with the close of escrow. And we were all there. We talked about it. I'm glad to see you were in agreement with it. Thank you for your time. And if you have any further questions, please call me, send me a text, email me, whatever's most convenient. So again, it's just, you can be nice about it, but the hidden theme behind that whole thing is I got to protect myself and protect my commission and protect any possible problem or litigation that may come up later. It's kind of too bad we all, as real estate agents, have to kind of think that way, but we do. And so please be careful out there. And as always, if a question comes up, reach out to Michelle, reach out to Ryan, reach out to me, and ask questions, because, together we can brainstorm and figure the best way to handle this situation. So again, use your brokers, reach out to your brokers. We're here to help. So, you're not bothering us. Please don't think that. We're here to help you. That's what I have.
Yeah, and I just want to add, guys, remember that feature in SkySlope. You can just add that email to all of your correspondence and it's automatically getting uploaded to that. We have a lot of agents that don't use that feature and it's a great feature. So up at the top of your SkySlope file, you've got that email. If you include that or just forward important emails to that email, it's going to automatically get uploaded into SkySlope and your communication is, accessible to us, accessible if we have an audit, all kinds of things. So just make sure you guys use that tool. It's a great tool.
Yeah, agreed.
Okay, great. It looks like we have one last comment in our chat from Roberta asking about the recent lawsuit on commission. Is this a subject that any of you would like to touch on today?
I'm not particularly familiar with what she's referring to.
Well, I think the point right now is that it's a lawsuit, so there's no decision on it. There's only, I don't think we'll have to deal with it until we have a decision.
Okay, awesome. Yes, also this meeting will be available as a recording on our Allison James University website on the Learn tab. So moving forward, if we have no further comments or questions, I'd like to thank our brokers for all their wonderful insight. A special thank you to Ryan for organizing today's topic and presentation. And of course, thank you so much to everyone for joining us today. And I hope you all have a wonderful week.
Thank you, guys.
Bye, everyone.
Thank you.
Thanks. Have a good week. Happy Thanksgiving, everyone.
Yeah, happy Thanksgiving.
Mhm.